and allowing this to be viewed. Looks like they're taking care of that. And I think we can call the Baptiste and Woods matter. Is Green correct?
Yes.
You got the name right? If we can bring up Mr. Baptiste and Miss Woods. Oh, all right. Are they on their way or do you know? All right. So for everyone's information, we're waiting on Mr. Baptiste to be brought over. Is it the motion for sanctions? We'll have to make them all. Ms. Green, do you by chance know Ms. Collins or Mr. Roach?
I do. I know both of them.
I wondered. No wonder I couldn't find it. There we go. Got it. Biggest case they've had in this county for forever. How long does he say that's gonna last me? Okay, well, do another motion. We have to. You give us an invoice.
Yeah, every time I get him paid.
So he'll let us know when the money's gone, I guess. Has he got money?
Yeah, he got whatever. I'm working with stupid.
We asked for $5,000 per investigator. That's what we get. Have you had the same problem? So. Yeah.
That's what we got.
Yeah, let's go ahead and have Kip him up here. All right. If we could bring Miss Wood up as well. On the record, this is CR 2025-232, State of Arizona versus Richard Baptiste and Anisha Woods. Mr. Baptiste is present in custody with counsel. Mr. Hamblin present on his behalf. Miss Woods is present in custody with counsel. Mr. Lee present. We also have here in the courtroom, Ms. Green with the county attorney's office and Mr. Friedley with the county attorney's office. We have on the Zoom call, Ms. Collins with the state, as well as Ms. Clace, counsel for victims in this matter. Date and time set for a status pretrial conference in this case. I, as always, hope prior to these hearings that we get things accomplished. I understand I'll address the parties. We may or may not have gotten much progress since the last one. We do have trial dates set beginning in June, and there are also, as I understand, a pending motion for a new finding of probable cause that I believe has not been ruled on yet by the court. I believe Judge Penrod is handling that matter. I don't believe there are a lot of other motions. There has been requests, probably by both attorneys, most recently by Mr. Lee, regarding investigative fees that we'll continue to address. The state doesn't need to weigh in on those unless they have a reason that they wish to. Starting, Mr. Hamblin, with you, anything to address in this matter as of now?
Yes, Judge. There's several different things I think that the court needs to address. We are As the court is well aware, what are we, 8, 9 months now that the defendants have been sitting in jail. Took the court a couple months to get the transcripts. After that happened, looks like we're almost 3 months now since filing a motion for a new probable cause finding. That hasn't been ruled on. And then now we're finding out that not only do we not have the autopsy, but it could be May before we receive it. So I think at this point, the appropriate remedy would be either to preclude the autopsy report from trial, or the state's going to need to dismiss its case and bring it back when it has the appropriate evidence to move forward.
All right, thank you. Mr. Lee, I'll turn to you. You don't have to reiterate if you
No,
want to
I'm
address the same things, but anything you need to address.
joining that motion for sanctions pursuant to Rule 15.7C, which provides the possible remedies for the court. And I think it's significant here. It says, and if the court, the violations impact on the overall administration of the case, the sanctions impact on the party and the stage of proceedings when the party ultimately made the disclosure. They haven't made it yet, but I think all those weigh in favor of dismissal in this case. I think, I don't know what other, these people sitting in jail, Judge. They're still in jail while the state's fooling around. I got a letter from Mr. Roach, the lead state counsel here, indicating to me that the delay has been they're reviewing 8,000 pages of DCS records. Now, you tell me why in an autopsy situation, you're reviewing 8,000 pages of their investigation. Number one, it seems lame. Number two, if it's happening, they're probably trying to coordinate what shows up in that report against what shows up in the DCS records. And I'm always afraid of that. But that's what's going on, and not apparently going to take till May to get that done. It's been since July, Judge.
All right, thank you. I'll turn whoever, Ms. Collins or someone else prefer to address the court first from the state.
The judge, I will address this. First of all, the complaint being made in a fashion of requesting the court to dismiss this case, to preclude an autopsy that we do not have, or to request sanctions is premature. It should be put forth in front of the court with the law and the rules, because as this court's aware, the state's disclosure requirements are a continuing basis. And so we do not have control of the Office of the Medical Examiner's Office, particularly in Maricopa County. The DCS records, the information defense counsel just provided to you, we received that information from the civil attorney at the Maricopa County Attorney's Office. We did not provide the DCS records. It was requested by the medical examiner. As this court's very fully aware of, and if we have to file a written response, we will provide a whole timeline. The state has been requesting that this autopsy report be provided. We had communication in late December, early January, and then I followed up about 4 or 5 weeks ago requesting more information. And what defense counsel just relayed to you is something that Mr. Roach and I received late last week. Was we were told through the civil attorney at Maricopa County Attorney's Office, they represent the OME, that it would be likely that the estimation from the ME is mid-May. To be clear, though, Judge, the state does not need the autopsy report, nor do we need the cause of death in the autopsy report to present our case, to approve our case. That's a part of the motion that I know is in front of a different judge in a different facet. But what we've charged these defendants are with felony murder based on child abuse. And they have hundreds of pages from the hospitals, 2 hospitals, a couple dozen medical professionals. And so from our perspective, preclusion is not right because we do not have this information to give them. A dismissal is completely inappropriate because we believe we have the evidence to prove it. But to ask the court to consider this now is completely premature, and a motion should be put in front of the court. As to when we will get the autopsy, we have relayed to this attorney, who is somewhat the conduit, because when we call the medical examiner's office, they do not return phone calls or emails. This is the best communication we've had. We have expressed that these defendants have asserted their Rule 8 rights, that our trial is set the first week of June, and we are working to see if we can get it sooner. But we have no ability as the state of Arizona to rush this. They are an independent agency. And so that, Judge, this is the best we can do. But for this, the point of the perspective of the state, we have been asking for it for months. We filed the court order on October 20th. So we want it just as much as defense counsel wants it.
All right, thank you, Ms. Collins. One question on that, Ms. Collins. I understand the arguments from both sides. Have you reached out to the Maricopa County Attorney's Office to just discuss the situation that you're currently in? And if they have no way or contact or influence there, I just can't imagine that if this case was being prosecuted by Maricopa County, that they would be getting the same answers that you are. Maybe they would, but it's tough to believe.
So ironically, Judge, the communication we've had is that Apache County is quite efficient, given the Rule 8 circumstances. That was what we were told. So we were informed that in general, the autopsy reports come out within 90 days. We were told child physical abuse cases can take several months beyond that. I don't think this is a case, because our cases in Apache County with some prosecutors that are from Pima County, I think this is based on the overall effect of what occurred in this case involving DCS. I think whether or not they have taken into consideration the public knowledge of the case and the media, I have no idea. That is not in my purview. But the idea that they requested, that they got the DCS records in some capacity, Judge, and that was not from the state. That was not from us as prosecutors. So they are trying to do their due diligence. What we have been told, and the individual I've been talking to has represented the OME, it sounds like, for the last several years. It doesn't feel like something that can be rushed any more than the pushback that I have been making every few weeks, Judge.
All right, thank you. One other regarding that is, do you have the state, that is, have you disclosed the same DCS records in this criminal case?
Yes, and they were disclosed a while ago, Judge.
All right. On those issues that have been brought up thus far, anything additional that needs to be addressed by the state?
Judge, I do. Oh, go ahead, Nicole. Sorry. The only other thing, the only other thing I will add, and then Miss Green can go. We've spoken before about a questionnaire. I know that it's coming up soon where we would be needing to discuss this. We've discussed it before and said we will discuss it down the road. I'm just mentioning, I think a questionnaire needs to be done sooner than later. So beyond that, Miss Green.
All right, thank you. Go ahead, Ms. Green.
And Your Honor, all I wanted to add is I'm sitting as third chair at this point. So our office will continue to assist with the prosecution, but we're continuing to defer to Ms. Collins and Mr. Roach as we move forward.
All right, thank you. The court, Mr. Hamill, go ahead.
Judge, just to clarify, I don't think that anybody is accusing Ms. Collins or Mr. Roach of intentionally dragging this on. But something that seems to be overlooked here is the medical examiner is also the state. They're both the state. So whether it's the prosecutor's fault, the medical examiner's fault, the police officer's fault, that's all the state, that's all the plaintiff. And we're just a couple months away from the beginning of trial. I don't think it's premature for preclusion, especially when they're saying We're not expected to get it until sometime in May. Ms. Collins indicated that they don't need the autopsy to proceed. So I don't see the harm in precluding it then, and we can just begin trial on June 2nd.
All right.
Judge, if I could speak to that brief,
Just let me see if Mr. Lee has anything, and then I will turn back to you, Ms. Collins.
Oh, Judge, I agree with that. If they don't need the autopsy, then exclude it if you're not going to dismiss the case. But if you continue the case, that's another option under Rule 15 that you have, is to continue the case. If you're going to do that, our clients need to be out of jail during that continuance, because they've been in there a long time just waiting for silliness.
All right. And for all the parties, I do not intend to rule on the motion, of course, here from the bench today. But Ms. Collins, if you need to address any response, go ahead briefly.
I just want to address the fact that I candidly spoke to the court that the state doesn't think that the autopsy is necessary to prove the charges based on what is being said in court. However, what I would just say, and again, we can handle this through the litigation and motion response, preclusion of it then affects the defense as well. And so the state should not be precluded from it. While the OME is a state agency, we do not have the same connection to them as we do, for instance, the Apache County Sheriff's Department. So there is nothing further the state can do as proactive as we've been. So we will wait until there's anything further in front of the court, Judge, before we act.
All right. Thank you.
Your
Ms.
Honor, may I-
Clace, yes,
yeah.
go ahead.
May I be heard? Thank you. I do not, I'm traveling, so I'm sorry that I'm not appearing with video on. I do not think there are formal motions that have been filed at this point to dismiss or preclude, but on behalf of the victims, I would object based on their constitutional rights to justice and due process and to be treated with fairness, respect, and dignity. It's unfortunate that it's taking as long as it is for this report to be disclosed to the state and to the defense, but no one, I mean, the counsel for the medical examiner hasn't appeared at these hearings. Maybe that's an option, but I know this has been an issue the last few hearings, but we would object on any, if the court is thinking of dismissing or precluding, I do object on behalf of the victims. Thank you.
Thank you, Ms. Clace. I won't again rule on the oral motions made today. I know that the court and the judge that it's assigned is very aware of the pending motion for a new probable cause finding. That one would, depending on the outcome of that, of course, very much affect Rule 8 time, other things in this case. But I don't have any control over that other than to say that I know it has been assigned. It's being reviewed, and I'm sure that judge will rule on that as soon as able to. Regarding the request for sanctions or request for dismissal, I won't grant those motions today. I would ask if the defendants wish to make those more formally, that they put them in writing and give the opportunity to the state, counsel for the victim, all the parties to be able to address those. I will state for all the parties information that I do understand both the defendant's point of view as well as the state's at this time. If the court thought it would be helpful to have an order to show cause with counsel for the Office of the Medical Examiner in Maricopa County, I wouldn't hesitate to do that. I don't want to start a fight that would give them extra reason not to continue to move forward along their planned route. Although the timeline seems much longer than really necessary, what I don't know is when they received in the Office of the Medical Examiner all of these DCS documents. I do understand why they are, from the medical examiner's perspective, needing to review them in order to do this. It's easy for us to say that that doesn't affect, but I know in their training and experience, it does very much affect the results of an autopsy report, having all of that full information related to the history of the deceased person, as well as those that will be addressed or causes that will be addressed within that autopsy report. I will also state that I understand for the defendants that I understand the reason for their oral motions today. I understand that at some point the court may have to consider, not only consider, but potentially grant some of the possible sanctions mentioned. The one I'm most concerned about with the timeline as we have it right now is the defendant's ability to be prepared for trial if it's disclosed mid-May, because they might need at that point to hire their own expert. I would encourage them, of course, to be thinking along those lines now, but it is also clear that there's limited things that they can do at this point without an autopsy report to prepare. I also understand that we've set the trial, I believe at the time, at the request of all of the parties. I could be mistaken about some of that, basically at the last possible time under the defendant's Rule 8 time limits. And so we just don't have much flexibility there. Again, I'm not granting any motions, but I'm addressing the court or the parties to let them know that the court is taking those motions, those possibilities as time moves forward seriously. I do thank the court for Ms. Collins, for the reminder regarding the juror questionnaire. I will, in my office, follow up more on the details that we need there. With our currently set trial dates, we will try to get that out to the parties sooner rather than later for a chance to review that before it's sent out to any jurors, of course, as well as I'll try to firm up what kind of time limits the court needs to be enforcing there to try to get as effective as possible responses prior to our trial dates, hopefully to make our jury selection process more efficient and a more better use of the time when we do come here to court. On that note, we've set right now, I believe we're set for 8 out of 9 weeks through June and July. I could be off by one on those. 1, 2, 3, 4.
Second today. Yeah, second to exactly 3 times.
I think that's correct, through the 31st of July. I am hopeful that we can compress that time schedule down. I think it's probably a very moving target right now, not only especially for the defense, but also for the state to some extent, as we're talking about the possibility, not any decision made, of whether or not they'll have this report, will have it disclosed and have it in time to go forward for all of the parties. But I will consider those motions, continue to consider those motions on behalf of the state. I would encourage and definitely ask for those to be made in writing so that they can be addressed by the parties before decisions are made there by the court. Mr. Lee, something you needed to address?
Does the court, expect Judge Penrod, is he waiting for that autopsy to make his ruling? It's been 3 months.
I haven't read those motions. I don't believe there would be anything there. I think it's just regular course of business and getting everything done. I think just in looking at the file, there was some requests made to extend time, etc. I don't know if that was on both the state and the defense, but at least some that extended things there. Again, I believe he's very aware of the issues and dealing with the matter that's before him correctly and timely for him, although we would love all of us on this side to have that sooner rather than later. I think it will be coming rather soon. It'll of course be disseminated to the parties, and if it requires any changes as we move forward, we'll of course address that with the parties as soon as possible. I don't believe we have any other dates on the calendar right now. I would like to at least check in on the case sooner, much sooner than any other pretrial dates that we have now. I don't want to get together just for the purpose of getting together, but hopefully to have some update. I'm looking if this 11 o'clock hour on Mondays in general works for the parties, would probably continue that. I'm looking at Monday, April the 6th in
April the 6th.
just over a month's time.
At 11 o'clock.
Mr. Lee, any objection or issue with that date and time?
No, sir.
Mr. Hamblin? Ms. Collins, will that work for the state?
Yes, Judge.
And Ms. Clace, will that work for you as well?
Yes, Judge, thank you.
All right, I'm gonna set it for a pretrial conference status regarding, of course, ongoing disclosure issues. We will definitely have an update regarding the motion for new probable cause finding that might change that, but at minimum, we'll be able to have that result by then. I also hope to have by then, with my staff, at least a clear understanding, if not actual juror questionnaire available to provide to the parties. I'm not going to wait till that date. If we have it before, we would send it out. But hopefully, at least by then, a very clear plan regarding that moving forward. Are there any additional issues that need to be addressed by any of the parties today?
No, sir.
No, Your Honor.
All right. I do thank all of those who have appeared today. Appreciate it. We will be adjourned in this matter until April 6th. Thank you. Mr. Hamblin, I believe Mr. Corder showed up. I don't know if you have any time to address that, or in a minute or two, we'll address that if that works. Mr. Corder, just a moment. Mr. Hammond will get with you when he can.
Yeah.
You can have a seat.
I'll step in for Mr. Daniel Taylor, Judge.
Pardon me.
I'll step in for Mr. Daniel Taylor.
Thank you. I appreciate that.